Brooklyn snow and ice slip and fall lawyer. Landlord shovel duties and winter claim guide. Snow and ice left on Brooklyn sidewalks can turn an ordinary walk into a serious injury in seconds. New York law places clear responsibilities on property owners to keep sidewalks reasonably safe after winter storms. Under NYC Administrative Code Section 7210, most property owners are responsible for injuries caused by unsafe sidewalk conditions next to their buildings. This law shifted liability away from the City of New York and onto landlords and other property owners. Landlords of apartment buildings, commercial properties, and multi-unit residential buildings are generally covered by this rule. Owner-occupied 1, 2, or 3 family homes used exclusively for residential purposes are usually exempt from this liability. Even exempt homeowners can still be responsible if their snow or ice removal efforts make conditions more dangerous. Improper shoveling, salting, or drainage that creates ice buildup can establish negligence. To succeed in a claim, an injured person must show the property owner knew or should have known about the icy condition. Actual notice exists when a landlord or property manager is directly aware of the hazard through observation or complaints. Constructive notice applies when ice remains long enough that a reasonable inspection would have discovered it. Property owners are not allowed to ignore snow and ice simply because no one complained. Landlords are required to clear snow and ice within 4 hours after snowfall stops under NYC Administrative Code Section 16123. The 4-hour window does not count the overnight hours between 9 p.m. and 7 a.m. Sidewalks must be cleared to a width of at least 4 feet rather than leaving narrow paths or icy patches. When ice cannot safely be removed, owners must apply sand or salt and remove the ice once conditions allow. Corner properties must clear sidewalks on both street sides within the same legal time limits. Failing to follow these rules can result in fines and can also be used as evidence of negligence in an injury claim. You generally cannot sue during an active snowstorm because the law recognizes a storm in progress doctrine. Temporary breaks in snowfall do not end a storm for liability purposes. Claims are also barred if a fall occurs before the legal snow removal deadline has passed. Open and obvious or trivial conditions may reduce or eliminate liability under comparative negligence rules. In Brooklyn, slip and fall victims may recover compensation for medical bills, lost wages, and pain and suffering. Property damage, such as broken phones or glasses, can also be included in a claim. Most claims against private property owners must be filed within 3 years of the accident date. Claims involving government-owned property have much shorter notice and filing deadlines. Working with a lawyer can help identify liable parties and preserve evidence before it disappears. An experienced attorney can evaluate weather data, inspection records, and photographs to support a claim. Choosing the right law firm matters when winter injuries create long-term medical and financial consequences. Kucher Law Group is a Brooklyn law firm that represents people injured in snow and ice slip and fall accidents. If you were hurt on an icy sidewalk, speaking with a lawyer promptly can protect your rights. To learn how a qualified attorney can help, contact Kucher Law Group at 929-563-6780. Kucher Law Group is located at 463 Pulaski Street No. 1C, Brooklyn, New York, 11221, United States.